Coming up on this program, we show you how to get connected. Find out how to choose an internet service provider. This program, discover we show you how to get connected. Find out how to choose an internet service provider. This program, discover we show you how to get connected.
We did figure that out. It's the little things you don't remember about the big things that end up fucking everything up. I hope everybody's doing well today. Vape has been living in my boobs, my cleavage, and it's warm. It's very warm there. I hope that everybody had a wonderful day. Today is indeed Thursday, August 22nd. And it is with great honor that I bring you more people that fail to pay their child support. Sorry. You know, I had set everything up, but in reality, I didn't set everything up. I did what was important to me. I rolled a joint. I grabbed a drink, and then instead of setting up the stream properly or moving my mouse closer to me, which is why I'm like reaching. Am I still echoing? Or is it fixed now? At the beginning NPC I was. It's going to drive away people left, right, and center. You might have two windows open. I do that a lot. Anyways, so now I'm going to bring my computer mouse closer to me. And hi, MB. Hello, everybody. Let's just check and see. That's a good point, Streamlabs. Everybody needs to do a med check. Take your meds if you've got them. If you don't know what, or if you don't have any meds to take, come on down to the chat and tell us what that's like. Leave a comment. We'd love to hear about it. So we're going to start off today. MB, I have something very local for you that I imagine will be making the news in your town tonight or tomorrow. I was perplexed when I was watching this hearing why it had drawn such a crowd. And it wasn't just the name of it. I was just like, what the fuck? Now, don't get me wrong. This is interesting only to us because we're weird legal nerds and we enjoy these types of tit-for-tat spats. But it's not a personal spat. Maybe it is. Why don't I just shut up? First, we're going to watch the child support cases. Then we're going to watch that. It's going to be a good time. I worked hard today. I worked hard. If you believe me, please hit the like button. If you don't believe me, please hit the dislike button. I check, and I like to see that. Vince, you have gabapentin capsules in each nostril. Oh, let's not talk about that phase of life. Anyways, no, seriously. We have friend of the court hearings from Michigan. Interestingly enough, watch what happens at these hearings. There's a lawyer there. I know we were talking about this last night, and I'm half joking, half not. The reason I mention it is because this is, I think, further along in the process, or something, or a different county, perhaps, even.
Good afternoon.
Give me a second. Ma'am. I'm not fucking ready for it yet. Okay? But we do need to talk about one thing first. Oh, how do I talk? No, I need to think about how to talk about this without incorrectly without incorrectly triggering something. Anyways, not sack rider, nut sack rider. I love that. Hold on. There we go. And I got this still. Dun 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 dun. Sack rider. They call me that sometimes. Oh no, not that kind of trigger warning. Honestly, I am more of I'll just be upfront with you guys. I'm still worried about the memberships being gifted out, and so I wish I could like put a be back later sign on that button. I can't, but I don't know. I've been looking into it. Also, oh, right, before we get going, I got a fucking bogus, absolutely bogus email from YouTube Daddy earlier today about a privacy violation on a 3-month-old video. And at the end of this video, I will share the link with you for that video. And if you would love to go and, if you want, you can check it out. It will probably be taken down in the next 2 days because the privacy complaint, they're supposed to specify like when the privacy violation occurred, and they said it was from 1 minute to 37 minutes. It's a 37-minute video. So, and I already scanned it. It is not, I don't think that there's anything in there that violates privacy. It's a court hearing. It's a Thurston TPO. But anyways, it's frustrating because YouTube Daddy doesn't care. If it was easy enough, like, for me to just blur out whatever paperwork they might be talking about, but they're actually, liars, allegedly, in my opinion. I just find that people utilize the system incorrectly a lot, so they're just literally lying because they're probably embarrassed. So that's why at the end of today, I'm going to give you guys that link. I want you all to watch it, memorize it, and make sure it never dies. Never dies. Also, I've already downloaded a copy of it just in case. And it'll, I don't know, goes in that naughty folder, and not even the good naughty folder. You know, I love my naughty folder. No, it's not even any of those good cases. It's an innocuous, stupid case. And it's not alive. It was a video I made. Even more frustrating. Regardless. Okay. This is where we're at right now. We have some losers. We are going to get out the excuse counter because there's some doozies in this one. And, yeah. Let's just enjoy. Let's enjoy this, shall we? Let's enjoy this.
Mr. Pulaski.
Good afternoon, Your Honor. Ron Pulaski with the Kent County Front of the Court. Presenting Jesus Beals. Mr. Beals has one case at our office. That docket number is 1997-005-180-DS. Jesus Beals versus Sarah Allegrani Rome. I probably pronounced that wrong. This is an arrears-only case involving one child, that minor child emancipated back in 2012. Leaving behind an outstanding arrears balance of $40,828. Mr. Beals was court ordered to pay $400 per month towards these outstanding arrears. In regards to the last payments being applied and received, the last one applied was May of last year in the amount of $133. Since that time, we've not had any payments applied by Mr. Beals. A brief history on the case, Your Honors. We've had a total, our system can only go back to, I believe, 2003, 2006, but we've had 13 show causes, 12 bench warrants, I counted 5 prior contempts and then I stopped after that. It appears that there may be more. The last contact we had with Mr. Beals was back in September of 2013. And that's when he was arrested, or September of 2023. I apologize. He was arrested on a warrant, and he was released with the stipulation again to pay the $400 per month or report 20 job searches. Back in September of last year, when I talked to him and released him on that, he was released and he failed to pay report. We had a show cause back in April 24th of this year, and he failed to appear at that show cause hearing. I did speak with Mr. Beals this morning. He informs me that he does live here locally with his brother. He doesn't pay any rent. He has a total of 5 children. He has some college level of education. He didn't report any assets or vehicles that he owns. And he lives off his family. And he's
Something is about to come up here, and I'm going to admit something to you guys that will probably make some of you laugh. Let's just listen to the rest of this part, and then before anybody else speaks, once Mr. Pulowski is done, I will tell you what happened. Maybe you can guess. Maybe you can guess.
States that he donates plasma from time to time. He also has a history of roofing. Back when I released him last year, he informed me that he is a roofer, gets paid under the table, and has been doing this for the last 20 years. In regards to other assistance, he does receive food assistance. He did claim that he has been dealing with depression issues, but hasn't seen a doctor in over a year. He did inform me that he does drink and smokes marijuana on occasion. He's not on probation or parole. He has 5 prior felony convictions. And I guess that would be all, Your Honor. Thank you.
5 prior felonies, 5 kids, 1 to match each of the kids there. No, here's the thing. I was listening to this, recording it, and working, and I heard him say rougher. And I was like, rougher? I don't know what that is. And here's the thing, when you type rougher into my Google, well, let's just say it's not work appropriate what comes up. So then I got distracted, but then I realized he was saying roofer. He means a roofer. Somebody who fixes roofs. But again, at that point I was already very distracted, or distributes roofies. Can you believe he has a kid that emancipated in 2012? That's a while ago. How young? How old is this dude? Anyways, let's see what. This is his lawyer over here, who does appear to be slack-jawed and have been brought in by a hologram from the set of Cheers, it appears. Honestly, doesn't he look like he could just hang out on Cheers? Christopher Engelby, howdy. I wanted to ask you a question, Chris. A question. Have you had crumble cookie ice cream? I just saw a video about it the other day. Amazing. Hi, Sean. And yeah, CPAP machine. Hi, Robert. How's the future? Wait. Isn't Germany behind? No, is it ahead? Is everything ahead? Everybody's ahead. Everybody's ahead, Paisley. Get used to it. Oh. Yeah, we're not even going to talk about what just happened. Let's just get fucking rolling.
All right, Mr. Miller.
Thank you, Your Honor. I did have an opportunity to speak to Mr. Belize. He indicated the big part of his problem is that he has seizures, particularly seizures when he drives. He's been on the Family Medical Leave Act since January of 2023. He's in the process of trying to get Social Security. He indicates that he cannot work because of his seizures and his the disorder that he has. He doesn't have any money now. You know, we did the 20 job searches. I don't think would do him any good. What I would propose is just let's put this off a little bit until he is able to apply for Social Security. But until then, he just simply has no money, but he can't work. So ask the court to not find him in contempt because he's unable to work, and then have him released today. Thank you.
Okay, does he have a doctor's statement that indicates that?
Not yet.
Well, actually, I do.
Oh, Chris is pushing the limits and we love him for it. Thank you, Chris. Let me click it and see. Look how nice it looks. Hold on. Hold on. Let the chat catch up. Oh, I love it. It says gift because you're a known gifter and giver. And I just love that. Thank you so much. Although I'm so worried. YouTube Daddy is so finicky lately. So finicky. But thank you. And legit, I just dropped my just rolled joint into a glass of water. That's why I was mad. But I luckily got it out in time. And I saw the gift was given. I know. One was given yesterday too. I'm just nervous. I love you guys. I want our little group to get bigger. Anyways, I managed to salvage the joint. I cut the end of it off that was all wet, and then it's going to be fine. Hi, Erica. Hope you're well. Thank you again, Chris. Welcome, Nana, Laura. I do see, I can't click on those for this. That would be terrible. That would be terrible. Terrible.
I do from my doctor in January of 2023, but it's in my chart, or you got to get a hold of my doctor. But there is a letter,
Okay.
yes, and it restricts me.
Any reason you didn't provide that to the front of the court? That would have kept you out of here today.
Yeah, I've been in it. I was arrested last year for 2 domestics and an arson, and I was in and out about 6 times for child support warrants, violating.
What a year he's had, ladies and gentlemen. Did you hear that? Did you fucking hear that? Whew! 2 domestics and an arson. But I still love her so much. If she wouldn't make me hit her, I'd love her just a bunch. That's not even funny to joke about, Paisley, in song. Domestic violence is real and serious. Sorry. That's terrible. What is the judge? Look at the judge. She's like,
my bond, and I did a total of about 110, 115 days from April 17th, 2023 to April 9th of this year. I was released. And I've been looking for work, but because of my condition, I'm a liability. Part of my job was operating heavy equipment. I was certified to train people on 4 industrial vehicles. My doctor restricted me from doing that. And at the same time, I troubleshoot machines, which made me a liability because I got to test them when they're running and I could kill myself. So I went out on an FMLA and I lost my job, my house, my car, custody of my youngest daughter. And that's where I stand right now. I got to have an MRI done on my brain. I recently had a seizure, landed on the crown of my head. And a week after that, I was a victim of a crime, which is still in court. I got kicked in the head, which didn't help my condition.
No.
Okay. So are you saying that we don't care. I shouldn't say we don't care. The front of the court and the court doesn't need.
we don't care. Actually, we should just, I've got it run to 0 here. Let's just go back and see if we can catch all that. I think he said, he's got 5 kids. Here we go.
I did a total of about 110, 115 days from April 17th, 2023 to April 9th of this year. I was released. And I've been looking for work, but because of my condition, I'm a liability. Part of my job was operating heavy equipment. I was certified to train people on Ford industrial vehicles. My doctor restricted me from doing that, and at the same time, I troubleshoot machines, which made me a liability because I got to test them when they're running, and I could kill myself. So I went out on an FMLA, and I lost my job, my house, my car, custody of my youngest daughter, and that's where I stand right now. I got to have an MRI done on my brain. I recently had a seizure, landed on the crown of my head, and a week after that, I was a victim of a crime, which is still in court. I got kicked in the head, which didn't help my condition.
No.
Okay. So are you saying that well, we don't care. I shouldn't say we don't care. The front of the court and the court doesn't need a lengthy explanation of why you're not able to work. Just verification from a doctor that says that you are not able to work, or that you're able to work with X, Y, and Z restrictions. That's
I can get that. I can get that. I've been in and out of jail literally all year.
All right. Is there someone that can get that for you?
Not that I know of. My doctor's office can probably fax it over here. It's a letter it's for my work, and it's from January of 2023, and it's in my chart because I had to show it to my work, and then I went out on FMLA.
Okay. Mr. Pawlowski, do you have any suggestions on?
Your Honor, in regards to his statement about providing or having medical documentation back in January 2023, I talked to him September 2023. We went over the same information that I went over with him today, and he didn't mention anything about seizures. And it was at that point in time that he mentioned about the roofing as well too. I can fax or put a kite over to the jail for him to sign a release of medical and get in touch with his doctor that way. So either if he is found in contempt and you order a dollar amount or days served, or we can work on that in addition to that. And if he pays or I get the medical documentation, I can release him on either or. But yeah, he's not provided us any recent medical documentation indicating that he's not able to work. So
sir, when was the last time you saw a physician?
January of 2023.
So that's over a year and a half ago.
Yeah, I kept coming in and out of jail. I came in April, released July, came back September, released September, came back November, released December, came back January, released February, came back around March, and was released in April.
Okay. All right. Mr. Miller, any statement you'd like to make?
Thank you, Honor. I think if we can get the doctor's letter and it shows that he's unable to work, I think then he shouldn't be found in contempt. So
No. I'm sorry, but the doctors know that from fucking last January? No. Those notes don't last that long, and I'm not all about going to the doctor every minute. I'm not. I don't want people to unnecessarily use doctors for administrative hurdles that their workplace can use to dissuade them from taking sick days. But, and that's a whole thing that I have a problem with separately, in case you never knew that. But, unless it is in his chart saying he's permanently disabled, unable to work ever, then I don't think that it is as good as he wants it to be. Plus you still have to pay, bud. Like, these are, I don't know. I'm feeling angry about it. And that's true. Lots of people with seizures work. He was in and out of jail. Like, that's some excuse, you know? But yeah, I don't know. I just think he's full of excuses and a whole lot of bullshit, to be honest with you. like 13 of these show cause hearings and he doesn't know how to do it and they didn't know he had seizures? Oh, don't forget he got kicked in the head. Lisa, you made a pee-pee. Are you okay? Or do you mean a literal pee-pee that I have to check?
I guess we could work with them. We've got people here that can work with them to help get that letter. We've got some social workers that might be able to help him do that.
All right. Well, I think what I'll do, given the circumstances, is I will adjourn the hearing.
Okay.
I don't want to make some conditional findings without knowing what we're dealing with here. But I would expect to be able to get that information to Mr. Pawlowski within 7 days.
Yep.
Because in the meantime, I'm going to hold him.
Yeah, you bet.
Okay.
Okay.
All right.
All right. Wow, Lisa, thank you so much. You're so sweet. And in the pee-pee. Oh, love it. You are amazing. Let me make the sound for you. This will, let's see what sound it makes when I click this. Wrong sound. Who the fuck is John? John, other than John, hi. I heard that you might be away tomorrow with your first wife's passing. I wish you well. Also, didn't mean to call you out by your name there. What the fuck? There. This is a test to get the sound for Lisa. Thanks, Lisa. You're amazing. I love it. So they're keeping him in jail. They're keeping him in jail.
Thank you.
Yeah, thank you.
It's to be critical, sir, that you get that information, to
Well,
Mr. to the
I have, I have another case pending. I got court later on for another domestic second.
Okay, well, Mr. Miller is going to work with you or
Yeah,
somebody.
yeah, we'll work on that.
So, okay. All right. Thank you. We're adjourned.
Yeah, thank you.
Thank you. Mr. Belize, you can step out and tell the corrections officer to send in the other guy.
Have a seat, chair.
What is going on? Oh, here we go. Another loser, allegedly, in my opinion.
Hey, Mr. Pawlowski.
Ron Pulaski with the Kent County front of the court presenting Nathaniel John Tagle. Mr. Tagle has two cases that are off as the docket on its first case, 2010-012, 335DS, Nathaniel Tagle versus Amanda Kukowski. The case is charging $84 a month for the support of his son. His son's not due to emancipate until 2027. There's an outstanding arrears balance of $8,270. There is an order on arrears for Mr. Tagle to pay an additional $125 to work on those arrears. So on this case, his monthly obligation would be $209. His second case is docket number 2006-004. 839 DC, Nathaniel Tagle versus Katie Ann Daniels. There's a couple other custodial parents or custodial partners involved in this. It looks like the child was bounced around a couple of times between a few relatives. The child on this case did emancipate in 2022. There's an order for Mr. Tagle to pay on this case the sum of $176 a month. The current arrears on his second case is $36,869. The combined arrears between his first and second case, $45,139. His total monthly obligation between his first and second case is $485. In regards to payments, the last payment was through an income withholding order. That was for $70.92 back in March of 2024. In February of 2024, Mr. Tagle was arrested on our warrants believe it was, I believe he was arrested in Isabella County in February 2024. He paid a grand total between his first and second case, $3,118, the full bond amounts on those warrants. He was released after posting bond in Isabella County. He was court ordered to appear for a bond out hearing, and he failed to appear on that, and the warrants were subsequently reissued. A brief history on the case is we've had a total of 18 show cause hearings, 15 bench warrants, and greater than 5 prior contempts. The last contact we've had with Mr. Tagle was back in December of 2023 when he called to inform us that he had employment. However, we received no payments in December 2023, January 2024. We received no payments, but February 2024 is obviously when he was able to post the bond of the $3,000 plus dollars. He informs me that he resides here locally by himself. He doesn't pay rent. He has a total of 6 children. He did obtain his GED. He owns a Dodge Nitro, a 2014 Dodge Nitro. He does have a bank account with Fifth Third. He does have, in regards to assets, tools of his trade. He's not receiving any form of government assistance. He has no health, medical, or mental issues going on. There's no substance abuse issues going on. He's not on probation or parole, but he does have quite a few prior felony convictions. The most recent was a felony out of Ottawa County FOC, in which that was for felony failure to pay child support. On that case, he does have a case again with Ottawa. Again, in regards to employment, roofing, he does side work and claims that he owns his own business. He gave me a name and a phone number to his brother. I attempted to reach his brother to get a minimal payment of $600 on this, and I was unable to make contact with his brother. Thank you, Your Honor.
Mr. Miller.
Thank you, Your Honor. When I spoke with Mr. Tagle, he confirmed to me that he's homeless. He has a car. It's a 2008 Dodge. It broke down, so he's unable to use that to find a job. He does want to work. He says that he is employable. He thinks he can get a job fairly soon. He just needs to be out to be able to do that. As far as money, he doesn't have any money right now to put toward his obligation. The tools of the trade, that's not a liquid asset that can be sold or given away to satisfy part of the payment. So what we're asking for here is if the court does find him in contempt, that the court would order the 20 job searches. That's something that he's able to do right now. He can get out and start doing that. We talked about that. He said he could do that in lieu of making the payments because he just doesn't have any money. So I think that's the best option.
Yeah, that's the best option. No fucking doubt. Who in their right mind wouldn't rather make 20 job searches than a payment of $400 and some odd dollars? You know what the reality is? You know what the reality is? This money is not even fucking ever gonna show up for these women. 6 children. Sir, I hope for your sake that you are so dumb that you did it with 6 different women and they each are taking a piece. So stupid. Fuck. You think he can name all his children and their birthdays? I don't. I don't. I don't.
Here, let's get him out. Let's get him looking for a job, and then he can start paying his child support. Thank you.
All right.
Hello, Your Honor.
Mr. Tagle, anything you'd like to say?
Yes, ma'am. I've been going back and forth with Mr. Ron Pawlowski for quite a while now. I would like to express to you my case with my daughter, my oldest daughter, who he was talking about I owe the most amount of arrears to, Amelia Tagle. Now, it made it sound like she had bounced around a lot her whole life. No, that's not true. She stayed with me for most of her adult life. I was responsible for taking her to and from school, getting her back and forth to school from the time she's 4 years old till she's 18 years old. So I did that. Now, I don't know why my amount is so high. It's ridiculous, actually, because when her mother signed over custody to me when she was 4 years old, I had full legal, physical, and sole proprietary custody of my daughter. I never went after her mother for child support or for anything like that. And so what they're saying is that my dead grandmother that passed away quite a few years ago, I owe not that much money on. And my mother, who only had custody of her for a very short time, and then I got out. And
You just said she was never uprooted. But then you've just admitted that your grandmother died and then your mother both took care of this child to the point where the state sought child support. Oh, God. It's fucking gross. It's gross, dude. You're gross. You're gross. That's the ick for me. Ugh. No. No.
and I got custody again of my daughter. So I would like to get that taken care of, like, because they saying that I owe all this money to what to myself because I was the one that was taking care of her the whole time, Your Honor. And it's
that the time to have dealt with that would have been at that time.
well, like I've been
There's something called a non-retroactive modification of support statute that prohibits.
I've been trying to get it.
You can't talk at the same time, sir.
I'm sorry.
Let her talk.
I'm sorry. Go ahead, please.
There's something called the non-retroactive modification of support statute, which means we can't go back and make any of those adjustments. However, Mr. Pulaski, has there been an audit done in this case?
I can look at your request. I can get that expedited as well too.
Yeah, that way at least he can see exactly what time periods he was charged what for, et cetera.
Yeah.
So that I can do for you.
Thank you.
All right.
Now, as far as my son goes, like I know I owe on him, and I've been trying to do whatever I can to help his mother out in any way that I can. You know, like, and I've been told multiple times not to give her no money without going to the court, and that I know that hasn't worked out, so I've stopped doing that. And right now, where I'm at is I was trying to help my friend out. I was renting a garage from her on Quinn Street, so I was kind of investing my time and effort into helping her fix her house up because she's pretty much begged me to help her do it because nobody else would.
Your kids have to come first, sir.
No, I know, man. So, like, we're supposed to sell the house. She hasn't been paid any of the rent money that I've been giving her, and she hasn't been. I've been paying her rent. I've been paying the rent money that I give her, and she didn't tell me that the house was going to foreclosure and that she was getting it auctioned off. So it's like now I'm stuck with nothing to look forward to because I have my aunt invested in. She's a realtor in the case, and like I've asked and gone out of my way to help her, and it's kind of just turned around and backfired on me. So all these efforts that I've been putting forth to try to do the right thing, to better myself out of the situation, has just led me further in debt, and here I am with a broke down vehicle.
Okay, so when's the last time you had a regular job?
It's been. So I still am gainfully employed, but it's seasonal work at DJ's Landscaping. I had a regular job at a foundry off of 44th Street, which I went out and got through Indeed. But that fell through because my truck broke down around that time. That was this summer. And then so I had gotten it running, and then it broke down on me again. I have set up quite a few jobs doing roofing and siding recently, and lo and behold, those have fallen through the cracks too. But so I've invested most of my time trying to help her get her property fixed because that's the only way that I saw myself getting ahead of the situation, really. And
okay, so I'm a little confused. You said you are currently employed by DJ's Landscaping?
Yes, they're going to rehire me pretty soon here. Like seasonal work, I do plowing, and I'm a equipment operator at DJ's Landscaping. So like they were supposed to hire me recently, but my phone was off when I was supposed to be getting a hold of them, and they had to give the job to somebody else. But I still have a job there as a machine operator. I just have to wait till the snowfall comes. I also have a job with ABC Technologies off of my cousin is a manager there, and he said that as soon as I want to, and that I feel like I can get to work reliably, that he'll hire me back again. And another job that I have been looking into trying to get is at Corvec Technologies off of 100th Street. I'm sorry, off of Patterson, like towards the end of East Beltline by the airport. And so I have been looking, and I know I can get jobs. So I will get a job, Your Honor. And you know, I'm kind of just letting my business go because obviously I'm in no position to stay organized enough to handle that much pressure. And I will just go get a regular job, you know, and that's what I really want to do right now.
Mr. Pawlowski, is he eligible for the responsible parent program?
Let me take a look, Your Honor.
It's exhausting me, and I am exhausting to people with my ADHD. I'm aware of that. Hang out with me in person for a week.
I would believe he would be eligible for that program.
All right. Mr. Miller.
I think the program would be a good idea. Again, he says he wants to get a job and he is employable. It's just a matter of getting out there and getting a job. He unfortunately doesn't have any money right now, and his car is broken down. So I like the idea of the responsible parenting program. Get him out, get him a job, and get him working.
All right. All right, the court finds that a support order exists in each of these cases, that the defendant had notice of the entry of each of the orders, that he's failed to comply with each of the orders, and a large arrearage exists. That based on what he said today, that if he had exercised due diligence, he would have had the capacity to pay all, or at least some of the money's due and owing. It sounds like he has prioritized other things rather than focusing on the kids in this case or these orders. So the court will find him in contempt of court. I will commit him to serve 30 days in the Kent County Correctional Facility. However, I will suspend that sentence on the condition that he report immediately to the Kent County Front of the Court Responsible Parent Program, participate in that program, follow all the rules of the program, so that he can find employment and not wait for seasonal snow plowing jobs and things like that. Find it right away. And they will assist you with that. They also have some other incentives for going through that program. So I encourage you to take the opportunity that the court's giving you to do that.
Absolutely.
If he fails to cooperate with that program, an immediate bench warrant is to issue. And certainly that suspended sentence will be on the table at that point.
And Your Honor, did you have a dollar amount in regards to the suspended sentence?
I'll apply the statutory presumption, so $405.
Thank you, Your Honor.
Random.
You see
Good
how
afternoon,
quick it starts?
Mr. Pawlowski.
Shut up, Judge. Do you see how quick it starts puzzle videos? YouTube Daddy doesn't want me to work. I'm recording that, and then it's straight into a Karen Puzzles video, which YouTube Daddy knows puts me to sleep. That and 5-hour North Korea documentaries. Yes. I've recently watched a 5-hour plus documentary about entertainment in North Korea, which I find riveting. But that was Karen Puzzles. She's a puzzler, and she does puzzling, and she also has the most weird voice. But I respect the hustle. I respect the hustle. The girl lives at home. Lives in her apartment. She does puzzles all day for YouTube. She has fucking many more subscribers than I do, and she loves it. You know, you can just see. Oh, Mayor, 1, 2, 3, 4, 5. Thank you, Mayor. Thank you, Mayor, and thank you to the new members. Welcome to the new members. Whew. Oh, my heart. I see, in this version at least, I can see that they're all given, and I can see, you know. Anyways, I really want a puzzle. I actually want to do a puzzle really bad. I do. But I don't have the space or the patience to do it like Karen does, so I have to start small, I think. I'm gonna have to get a small puzzle, and do that. But I'm being influenced. Anyways, okay, what's next? Oh, right, we're going to Austin. Okay, we're in Austin. Hold on. I stupidly cut this into 3 by accident. Oh, okay. So here we go. Okay, perfect.
All right. Please give me a thumbs up if you can hear and see me properly.
Yes.
All right. Wonderful. Good afternoon, everyone. I think all of you have been before this court before. I'm Judge DeSetta Lytle. I'm here to hear your... Wonderful. Good afternoon, everyone. I think all of you have been before this court before.
Not quite all of us, Judge. I think I'll take a moment to introduce you to everybody else. This is in, Courtney, I love how... I love you so much. Just contrary. Thumbs down, she says. But I love it. Anyways, let me just give you a brief overview here. Unless it's totally sealed, cellulite yoga pants. And in that case, double check it out. Yes, Austin politics, and I find it interesting. I also think we're gonna see some what I think is good lawyering. We often see people bumble through things, which is odd because we watch a lot of criminal stuff, and criminal stuff is very serious. It matters a ton. People's lives, in fact, are at risk. And yet, and take this as you may, I often find in civil cases the quality of the lawyering to be higher, allegedly, in my opinion. This is an emergency hearing. Obviously, that's why I clicked on it. I was like, emergency hearing? Yes, ma'am. I'll be there. And so I didn't know what this was about before, but I did spend a good portion of my high school years and my early 20s going to town meetings and council meetings and voting in organizations in order to pass motions and follow basically rules of different organizations that are run by boards and votes because of the work that my mom did with a nonprofit and how hard it is in our city to pass different motions and different types of things. And so weirdly enough, I have a lot of experience with this. And then when I worked for the cruise ships, I used to go to these meetings as a representative for those companies when they, well, not those companies, for my company, who ran the cruise ship tours, to hear people complain about that. Because sometimes you just have to sit there and be a pretty face and listen and take notes. But this is a little bit different, and so I won't try and explain it anymore because you guessed it, there's a PowerPoint.
I'm Judge DeSetta Lytle. I'm here to hear your emergency motion. With us is the Judicial Executive Assistant and the staff attorney of the 261st. I remind you that you are in a virtual courtroom without a record, and we do request that you treat this as if you were in the physical courtroom, meaning The same rules of decorum are going to apply, although you will address the court from a seated position. The Travis County local rules are going to remain in effect. As a reminder to the parties, no recordings are permitted of these proceedings. No recordings or photographs are permitted, and violations of this or other instructions by the court may be punished by contempt of court. We are currently publishing through our YouTube channel. Specifically, this was set at 4 p.m. so that it is more accessible to people and to anyone that wants to observe these proceedings on the YouTube channel for the 261st District Court, which can be found on the web page, right on the front page of the 261st District Court. With that being said, I also want to talk about what the emergency court does and doesn't do. This is, again, there's not a court reporter here. This is not an evidentiary hearing. This is treated more as an appointment. So there is not unlimited time. There's going to be no more than approximately 20 minutes total for this. This is the consideration of a TRO, and the court, if it grants it, will be giving you a setting for a TI where a full hearing, an evidentiary hearing, could be set and heard as appropriate. With that being said, let's have announcements, and then we can get started with Mr. Alshire.
Okay, Judge, first announcement is, in this case, a TRO is actually not referring to a temporary restraining order, which is what I first thought. Remember, I had no info about that. But it is, in fact, not a temporary restraining order. It's something else. They're going to say it soon. It'll make sense. It's basically... I can't remember, and I watched it. Anyways, we'll find out very soon. Also, just so, I mean, they do a very good job of introducing themselves here. Is it resisting? No, it's like a, rescindment might be it. I don't know. Because I think it turns into an injunction hearing, the TI, a temporary injunction. But anyways, let's find out together. I'm doing a terrible job, I know. Thanks.
Yes, Your Honor. My name is Bill Ailshire. I represent...
Shut up, Bill. I took notes. I didn't write it down. Never mind. Keep going, Bill. Temporary injunction.
The plaintiffs, and I have with me co-counsel and plaintiff Bill Bunch. We are ready.
I see Mr. Bunch. Mr. Richards is also here.
Yes, Your Honor. I represent the mayor and the city council of the city of Austin, and with me is my paralegal, Karina Esparza, who will be assisting me, but she will not be speaking.
All right, thank you. Good afternoon. All right, Mr. Alshire, and help me with pronunciation again. Alshire or Alishire?
Ailshire.
Got it.
Thank you.
All right,
Yep.
You may proceed.
Mission that we sent this afternoon about 1:15 with a proposed order and our case authorities.
I do not see you anymore. Can you turn on your video?
Sorry, Your Honor.
There we go.
I
have received everything that was sent.
You have? Okay.
Yes.
Thank you. Your Honor, I may be one of the only attorneys practicing in this area of law that has also had to comply with the Open Meetings Act for the 12 years I was Travis County judge. But I'm also one just among many who are passionate about the need for transparency in government, including my clients in this case. As a factual matter, it is undisputed that the TOMA meeting notice at issue in this case regarding the charter amendments just said ordering a special election for the purpose of submitting proposed charter amendments to the voters. And that broad language was buried in the middle of a full agenda item, number 12 on the August 14th meeting of the City Council. The adequacy of that notice is a matter of law for the court to decide. Telling the public that the council will consider amending the city charter is on its face inadequate public notice of the subject to be deliberated without listing the amendments in the notice. It is tantamount to the council saying that they will consider amending the city code of ordinances in a regular meeting instead of listing the ordinances in the meeting notice that they will actually consider amending. By such wording, the public is not given a clue what substantive changes the council will deliberate. The term city charter is a category of topics or subjects. It is not a single subject as TOMA requires to be stated on the notice. Our argument that the topic of each proposed charter amendment should have been separately listed on the meeting notice as a subject is supported by the statutory requirements specific to charter amendments. I provided your honor a copy of Texas Local Government Code section 9.004 D and E that in relation to charter amendment elections, an amendment may not contain more than one subject, and that each amendment must be listed separately on the ballot so that voters can vote for or against each amendment. Ironically, on August the 14th, the council voted separately on each charter amendment, even though they had lumped all of those for being charter agenda item. I don't know why my video keeps going off. I apologize. Okay.
We have you back. Thank you.
Okay. The Austin Council does know how to properly post charter amendment election items on the agenda because they did so for the last charter amendment election held on May 1st, 2021. For the council meeting on February the 9th, 2021, when they ordered that election, the meeting notice lists each of the 5 charter amendments and petition ordinances as separate agenda items and gives a short explanation of the item that comports with, and that comported with TOMA. I provided you, Your Honor, a copy.
So TOMA is the Texas Open Meetings Act, and it is what governs all types of meetings and requirements in Texas. It is obviously law and upheld by law. And so what's happening is this guy, Bill, is saying that the Austin City Council didn't properly give notice that they're going to change something and they're going to do it through an election. And so they are coming to the judge to try and prevent that election from going forward because of this of them not following the TOMA, which is the Texas Open Meetings Act. And again, look at how much money and look at how many lawyers are on this screen. There is a staff attorney and a clerk for the judge, plus the judge, those 3 in the bottom. Then the top guy with all the books is the lawyer for the mayor and city council, and his assistant right beside him that won't speak ever, Karina, but you will do all my work, Karina. She's there too. And then we have Bill. I don't know who Bill is. I think Bill is probably like take one for the team community guy. I'm not sure. Shit disturber Bill over here. Thanks, Rachel.
Of those agenda items from the February 29th meeting. As this court may remember from the recent case that last heard on August the 7th, 2024 by SOS against the city of Austin for TOMA violations, TOMA section 551.007 requires the council to give the public a reasonable amount of time to speak to council on each agenda item. Because it is undisputed that on both July the 18th, 24 and August the 14th, 24, the council lumped all the charter amendments into one agenda item, allowing only 3 minutes to speak on all of the amendments together. the council again violated section 551.007, but just used a new twist, improperly lumping agenda subjects together under one item to try to get around compliance with section 551.007. They weren't necessarily in direct contempt of this court's order. They just tried to do a soft shoe dance around it. This is the second reason the council's approval of the election ordinance that we've cited in our pleadings for sections 2 through 15, just the charter amendments, should be eventually reversed and declared void and then temporarily enjoined from proceeding. Now, the basic rule of law on the adequacy of public notice under TOMA is well summarized in the case that I've provided to you in the city of Laredo v. Escamilla. In that case, they not only lay out the rule, but they cite to most of the other cases that are on point about the adequacy of a written notice. And the notice provided by the governmental body must be sufficiently specific to alert the general public to the topics to be considered at the upcoming meeting. And courts must be careful to ensure that the notice serves the core purpose of the act. General notice in some cases is considered substantial compliance with the statute, even though the notice is not as specific as it could be. The notice must be more specific, the court said, if the public has a special interest in the topic under discussion. So if the contents of the notice are undisputed, its adequacy is a question of law. The provisions of TOMA are mandatory and are liberally construed in favor of open government. If a governmental body violates TOMA, any actions taken by the body are voidable. Now, in Cox Enterprises, the Texas Supreme Court kind of reemphasized the point, and this was in 1986. Our prior judgments, the court said, should have served as notice to all public bodies that the Open Meetings Act requires a full disclosure of the subject matter of the meetings. The act is intended to safeguard the public's interest in knowing the workings of its governmental bodies. The public body's willingness to comply with the Open Meetings Act should be such that the citizens of Texas will not be compelled to resort to the courts to assure that a public body has complied with its statutory duty, unquote. Despite just losing a TOMA case in this court over the same issues earlier this month, it does not appear that the city of Austin will voluntarily, without court intervention, comply with TOMA. Now, on the issue of the temporary relief we've requested, in the context of TOMA, the plaintiffs qualify for the TRO in that if the city...
So this is like literally very similar to what we used to deal with when my mom worked for the nonprofit. One of the nonprofits she worked for was the Sierra Club of BC. I think they have the Sierra Club all over the world, but similar mandate to protecting natural areas, blah, 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 blah. Not that I don't think it's important. I do. And I actually think he's doing a really good job. The problem is that government is supposed to follow these rules. It's not cool if they're not following the rules. They shouldn't have to bring this lawsuit. And what he's citing right now is another case where they even straight out said, we don't want to hear this in courts. We want governments to comply with this because that is the way it's supposed to be. Yeah, so Sierra Club, yeah, so yes, a lot of time. And the reality is that oftentimes they're correct. There are rules and regulations about this. Basically what's happened is they're trying to jam something through when they didn't line it out and allow enough public consultation. Dangerous. And again, it very much concerns me when I understand the city fighting on, I don't know, I don't know enough about their politics, but I'll just say it doesn't go over well here when our city council argues with community groups, with lawyers. It's just not a good look. But people hate our local city council. Is that standard everywhere? That everybody hates whoever is in charge?
is allowed to continue with the election, the city's TOMA violations may not be adjudicated due to the short time frame we have left us. But we're in this situation because the Austin City Council, after starting the charter review process in March of 2023, decided to wait to almost the last minute, waited to August the 14th with a statutory deadline of August the 19th to call the election, to take final action to place the charter amendments on the ballot. And without final action by the council, a TOMA lawsuit was not ripe. Surely it cannot be the law that a governmental body can delay action, then violate the Texas Open Meetings Act with impunity because it left too little time for their actions to be challenged and stopped as TOMA provides. That's why we need immediate, even if temporary, relief. An example of temporary relief being granted in a TOMA case is
relief. Oh, what a relief it is to find that word. Temporary relief order. Not a restraining order. Relief. Oh.
is in the Finland v. City of Dallas case that I gave you. That was a federal case, but they discussed the element of our TRO of irreparable harm, and found irreparable harm was caused by the loss of the TOMA. Now, one last point. We found out yesterday from the Hayes and Williamson County elections offices that their deadline to finalize the ballot programming is next Friday, August the 30th. Believe me, I'm shocked to know that now. Therefore, we are in need of a quick decision. We sincerely want Your Honor's opinion of the law and our TRO decision on the record, even if procedurally we are now required to seek an emergency mandamus from the Supreme Court, given the shorter time frame in which this must be decided. I'd be glad to answer any questions or clarify anything for Your Honor.
All right, thank you. Mr. Richards. And then just, and you're on mute, but as a reminder, we are not on the record. You know, you mentioned you want a ruling on the record. We are not on the record, as I mentioned at the very beginning, what the purpose is of the emergency duty court and how it functions. So I just want to make sure to address that. And with that being said, Mr. Alshire, you can put yourself on mute so that I can hear Mr. Richards now.
May Mrs. Esparza be permitted to share her screen, Your Honor?
Yes, thank you.
Thank you, Your Honor. As an introduction, the TRO should be denied for the following reasons, which is slide number 1. The Texas Supreme Court, Karina, can you go forward one? Says that the courts lack authority to enjoin an election. Also, there was no TOMA violation. And then if the court could enjoin the election, it should not, because a TOMA violation does not require the invalidation of the ordinance. The TRO that is requested would reverse the status quo. The plaintiffs have no probable right to relief because there's no TOMA violation, and plaintiffs have no imminent irreparable harm, and balancing the equities favors the rights of voters to cast their ballots. We can go to the next slide, Karina. This is the plaintiff's original petition, and we're going to go in the next slide to paragraph 22, which is the application for a temporary restraining order, which clearly states that they asked the court to issue a temporary restraining order against the city from proceeding with an election. And so it's clear that the requested relief is an injunction prohibiting an election. If we can go to the next slide. This is from the Texas Supreme Court in 2022, in re Canoyan. The most fundamental individual liberty of our people is the right of each to participate in self-government. The right to vote makes self-government possible and undergirds the premise that government has the consent of the governed. So the requested TRO is to prevent.
Undergirds. Yeah, you heard that here. Undergirds. This is a terrible one. And it's so annoying, MB, that they're spending money fighting this, that they're like all this shit, and he can't even run his own fucking PowerPoint. Karina's over there not allowed to speak, doing all the work. You know, she typed all that shit out too.
The entirety of the city of Austin electorate from voting, which is heavily weighed in the equities against any kind of injunctive relief. And as we'll see in the next slide, the Supreme Court has made it clear that that's not permitted. So this is a 1949 Texas Supreme Court case that was about an Austin City Council election. And this is the Supreme Court saying that the court has adopted the view that it is beyond the power of a court of equity to enjoin an election or any incident to it, although the election may be called without authority and therefore absolutely void. And that authority is still good law, Your Honor, as I'll demonstrate with our next slide, which is Blum versus Lanier, which is 1999, Texas Supreme Court, which cited to the 1949 Austin versus Thompson opinion. And this was an election to amend the city charter. So similar to the case that we're talking about today, the plaintiff attempted to enjoin the city from using allegedly misleading language on the ballot. And the Supreme Court said, it is well settled that separation of powers and the judiciary's deference to the legislative branch require that judicial power not be invoked to interfere with the elective process. And then a further case law that is more recent even still is the In re Morris case, Texas Supreme Court from last year, which also cites to that 1949 Texas Supreme Court Austin versus Thompson case. And this was another voter challenge as to a proposed charter amendment, arguing that it violated state law. Again, the Supreme Court said it is well settled that judicial power not be invoked to interfere with the elective process. Now there's more slides on this particular case. It's very recent authority. If we can go to the next slide, Karina. Historically, the court has not enjoined elections altogether, even elections called without authority and therefore absolutely void. Mr. Elsher and Mr. Bunch claim that this is being called without authority, but even if they're correct in that, the court has said in the 70 years since the legislature granted the court statutory power to address violations of the election code, they have not once used it to altogether deprive the voters of an election. And then one more slide on this is after the election is held, the courts have far more robust role to play in evaluating the results and the process by which those results were obtained. The election code provides remedies for elections tainted by fraud, illegality, or other irregularity. A party may not file such a suit until after the election is held. So these three cases stand for the proposition that the Texas Supreme Court does not allow injunctions to prevent an election. Now, if the court did have the authority to grant the injunction, we believe that the court should not, and we'll show why. This is not an emergency. There was a work session in April, a council meeting in May, a council meeting in May 30th, another council meeting on July 18th, at which Mr. Bunch quotes himself in the pleading to say, I have to see you in court again. So over a month ago, Mr. Bunch was already planning to sue the city about this. And then at the council meeting on 8/14, he appeared, and then they waited for 5 days and filed this lawsuit and claimed that it was an emergency, even though the plan was to file this suit over a month ago, which would have given us plenty of time to provide adequate briefing and evidence to the court. Now, here are the election deadlines on the next slide. So the 19th, the day they filed the suit, was the deadline to order the election. And then as Judge Elshire mentioned, the deadline is August 30th for Hayes and Williamson to.
Did you hear what he called him? I didn't catch that the first time. He called him Judge Aylshire. I know he used to be a judge for 12 years. Do you keep that title even when you're then a practicing lawyer? Ooh, I think he slipped. I think he slipped. Because Aylshire is the other lawyer. He was a judge, he said, for 12 years.
To finalize their ballot. September 5th is the deadline for the Travis County to proof their ballot. The Secretary of State recommends electronic ballot testing by September 18th, and the deadline for absentee and military ballots to be mailed is September 20th. If the court grants a TRO, none of these deadlines can be met, and so the court will have prevented a decision on the merits with a TRO that is not allowed under In re Morris. Now, I'd like to talk about what notice was available to the citizens of the city of Austin. The Cox Enterprises says that the substantial compliance is sufficient, and as long as a reader is alerted to the topic, it is not necessary to state all the consequences which may flow. Then the next line shows you what the order, what the posting said, and then what I'm going to have my paralegal switch real quick and show you online live what information was available. So this is for the August 14th, 2024 City Council budget meeting. And if we scroll down to number 12, you can see that language that we just looked at is in this and says, ordering a special election for the proposed charter amendments. And then just a couple of lines below that, there's the first document that's the backup, is the draft ordinance. And anybody who is interested in what's going to happen at this meeting has access to the entire draft ordinance, which plaintiffs obtained apparently from here and attached to their pleading. It shows the ballot language and in red line, every single change that is proposed to the charter by these charter amendments. And so there is more than adequate information available to anyone who wants to know what the city council is going to do. All right, if we can go back to the slides, Karina. So the next slide is from Texas Supreme Court in San Antonio versus Fourth Court of Appeals. And this stands for the proposition that too much information in the posting itself is
Yeah, and then I fucked up. But don't worry, I kept going. We got it. We got it all. I went back like 10 seconds.
Antonio versus Fourth Court of Appeals. And this stands for the proposition that too much information in the posting itself is just as bad as insufficient information. The city council posting for this got it right. It said the general topic, which is what is required, and then provided for those who want to go further information, all the information about what was going to be proposed for the ballot and what the changes to the charter would be. And we've just seen that. So this next argument is that the agenda was a violation of TOMA. And this is from the Texas Attorney General opinion in 1998, saying that the agenda determination is aptly relegated to local practice and procedure. And because TOMA does not specify how the city or any other organization sets its agenda. Now, if we go to the next slide, they claim that the agenda items had to be separated into separate line items so that residents could speak on each item. But if we applied that rule to everything the city does, this would necessitate the city to grant time to every citizen to speak about each individual item included in the thousands of lines in the city budget. And this is an unreasonable proposal. So this is a perfect example of why the Attorney General relegates the agenda to the local practice. And the city's authority is to exercise how it sets its agenda. Now, there are 13 proposed amendments. The plaintiffs have not identified which of these they believe to be important. Some of them are, for example, Proposition J, which changes the requirement for municipal judges resigning to run for office to comply with the Constitution. And then Proposition M removes the affidavit requirement for filing a claim against the city to comport with the Tort Claims Act. And then Proposition N is non-substantive corrections and typographical errors. The request that 3 minutes for every citizen to speak on each of these 13 amendments is unreasonable, and an emergency hearing, which this really isn't because it was manufactured by deliberate delay, does not afford the court time or adequate information to make decisions about this. So in the next slide, there was no TOMA violation because the notice and backup documentation clearly demonstrate compliance. The agenda items are determined by the city, not by TOMA, and so that's not a violation. And because there was no TOMA violation, plaintiffs have now shown a probable right to relief, which is required for a TRO. Now, the next slide is from the Open Meetings Act Handbook of 2024, page 70 and 71, which says that even though acts in violation of TOMA are voidable, the Act does not require a court to invalidate an action taken in violation of the Act and may choose not to do so given the facts of the specific case. Given the facts of this case, which is an attempt to enjoin an election in violation of Texas Supreme Court clear precedent, the court should not invalidate the ordinance, even if the court is concerned there may have been a TOMA violation. Then another requirement for a TRO is the next slide, which is that it must be to preserve the status quo, which is the last actual peaceable non-contested status which preceded the controversy. The status quo is the city adopted an election order. A TRO reverses the status quo and undoes the status quo, and therefore is not an appropriate use of the request for an application for restraining order. Next, there is no imminent harm. Mr. Bunch may prevail on the voters of Austin to reject the charter amendments at the election, in which case there is no harm to anyone for that election having proceeded. Furthermore, as pointed out in In Re Morris, the election code provides for remedies for elections after the election occurs, and a party may not file the suit until after the election is held. That is the appropriate remedy if, in fact, there is some remedy for an improperly held election. And that is not imminent or irreparable and has nothing to do with what's going on this week or next week. That happens on November 5th and 6th. Finally, in balancing the equities, which the court should do in determining whether to grant a TRO in Texas disposal systems, the plaintiff had lost their municipal waste contract and knew about it for several months, and then waited until after the new contractor had spent $7 million to get ready to deliver on the contract, and then filed a TOMA claim seeking an injunction. And the Austin Court of Appeals said it was appropriate to consider the plaintiff's delay in seeking equitable relief and balancing the equities in favor of denying the requested relief. The plaintiffs planned to sue about this on July 18th, but waited until after the August 19th deadline. Finally, more importantly, with regard to the balance of the equities, again, the In Re Canoyan case says the most fundamental individual liberty of our people is the right to vote. The proposed TRO deprives the citizens of the right to vote on the charter amendments, and depriving the citizens of the right to vote is contrary to the public interest, which must be weighed in the balancing of the equities. We believe it's clear that if the court actually did have authority to grant an injunction prohibiting an election, that the balance of the equities weighs heavily in allowing the voters of the city of Austin to vote on the proposed charter amendments. And so in conclusion, the Texas Supreme Court prohibits the requested injunction. There was no TOMA violation. The TRO would change the status quo, which is an improper use of the TRO. There is no emergency, and the balance of the equities favors allowing the voters to vote. Therefore, the court should deny the application for temporary restraining order. And we will provide the court with the 3 Texas Supreme Court cases that were referred to at the beginning of the presentation and a proposed order denying the application for TRO. Happy to answer any questions.
I have no questions at this time, but I will note that nothing was filed in response. And so there are no, we checked and there are no filings in response at this time.
Is that a big deal? That seems like a pretty big deal to me. Especially since, did he spend all his time making a PowerPoint and he forgot to send it in? Also, I do like this judge, but she let them go on too long. I wanted her to be on a timer here. The lies, about 20 minutes. 20 minutes per person, maybe. But remember when she said they're not on the record? That confused me. So, I don't know. We'll see what... Well, look at his face. Karina? You didn't submit this?
As of right now.
Agreed, Your Honor. We have only had notice of this for 2 days, and we were not aware of a requirement to file a response. We're only required, I believe, to be here at this hearing and provide Your Honor with the authorities demonstrating why the TRO should not be granted.
Ma'am, you heard?
Yes, you can respond. Go ahead.
We served the city attorney's office on Monday morning as soon as we got a cause number, first of all. Secondly, we weren't provided. Let me get.
Jesus Christ, Bill, what the fuck is going on? What is going on? Why does he keep dropping out of the call? Honestly, I don't know. Do we think that's gonna matter? Seriously, and how can you come to the hearing with a fucking PowerPoint presentation and an extra person who doesn't speak? Ah! Yay! Hey, baby. It's on. Oh, look at that. I like that. You see how it says KCC crew 9 months? Mikey, you're coming in at the tail end of some boring, but not boring to us, legal wranglings. I really like how that says it. Also, 9 months. Thank you. What's up? Everybody say hi to Mikey. They are fighting. And, like, how do we know? Of course like, how can you show up with a PowerPoint but not a written answer? At least saying, like, no? I don't know. What's that? I can't see what it says. Oh, I see what it says. 5 months. Yay! Thank you. Too much to count. Anyways, so let's just see what, and that's my move. I do that.
Get my camera back on. We weren't provided any of this before the hearing, even though we provided ours at 1:15 this afternoon. So I'm trying to make sure that I address all the substantive complaints they had. Number one, the last peaceful event was on the 14th when they passed the ordinance, but that was in violation of TOMA. those cases, I'm real familiar with those mandamus cases on election law. And
you and I both know I am not meant to be a lawyer. I love critiquing them on YouTube, but that's a lot of school. Yay, Vicky. Oh, it won't work when I click on it there. I have to click on it over here. Yay, 9 months. Hey, Twitchy. And he's being snippy. I know. Also, yes, squirrel what? That's part of the problem. Plus, I prefer the YouTube law school that I attend every day.
They don't, those cases are not TOMA cases. Some of them occurred before TOMA was even set. And so what we have here is a question of whether or not TOMA is going to be enforced. If that it was the city that put the election in jeopardy by violating the Open Meetings Act in order to call it. So we've asked for temporary relief. Otherwise, if the election proceeds, we're not enforcing the Public Information Act. The public not only has a right to vote, they have the right to see how the stew gets made, and part of that depends on transparency and on public notice. It is not true that Mr. Bunch could have legitimately filed a lawsuit on July the 18th or any date prior to August the 14th because it wasn't ripe. And under the open meeting, before an open meetings came, you have to have final action for the court to then reverse. And it is voidable.
I believe your video turned off again. There we go.
Bill!
Okay. Let's see. By the way, the other thing that's mentioned in the suit I didn't mention today is that he showed the website. If he showed the first screen of the website at the city of Austin for the meeting, it would say it was a budget session. And then you have to click on that in order to get to that meeting date, and then you see it. Oh, the other thing about that you can use backup somehow mitigate an utter failure to post the meeting requirement. They have not cited a single case that says that the meeting notice is excused for its inadequacy if the actual subject is included in backup somewhere that somebody has to go read long legalese in order to even know what the subjects were. In short, the city's assertion of incorporation of extraneous documents to cure inadequate meeting notice language would gut TOMA section 551041's notice requirement that the subject appear in the meeting notice itself. And we are not somehow being unfair to the Austin City Council. They know how to do this. They did it the last election on charter amendments. And we haven't laid behind the log. I mean, it takes a little bit to see if there's someone that wants to sue and then get the petition ready and file it. So they acted on Wednesday. We tried to see if we could get signed documents, and they're not available online for some reason. And we filed that lawsuit very early Monday morning, asked for it to be expedited, and got it to everyone as quickly as we could. We also contacted this court to try to get the setting. With the only reason that we couldn't agree, the city attorney said they couldn't be ready until Thursday. Now we were ready; we'd be ready for Wednesday. So those, if there's other issues that Your Honor wants me to address, I'd be absolutely willing to. But I think that.
You know, could that be the one position I could be in? Because I can't work in government again. I've done it too much. It's soul-sucking in a terrible way. You know, what Vince said earlier is something that I found out. I remember distinctly. First of all, thank you, Mikey. I know you work harder than anybody I know. You're a great guy. got the check mark, doesn't show up in my chat anymore. That's like, you know, we love you, so you're just like family here. But anyways, I won't tell you which job I started, but I'll tell you I started a job. I was working with executives. I wasn't an executive, but I was working with executives, and I remember looking around a meeting and coming out of a meeting and being like, oh my God, that's the top. Like, that's it, Hayes. They don't have anybody else. There's nobody else in the wings that's actually running shit. That's it. And this is not good. Like, when you realize that everybody, like, there's a lot of dumb people that are in high up positions, you just like, oh Lord. And yeah, it's depressing. It's depressing. Anyways, let's listen to, I think Bill makes a good point. So, Save Our Springs, who is, funding this lawsuit, is, you know, alleging that they're not following the rules, but yet they knew how to follow the rules because they did it properly last time. And that actually tracks. That's a good argument. Only 57.8 thousand subscribers to go. Yeah, Nico, I am working it. But my goal is 100,000. I want that fucking play button. I will just continue to work at it. But anyways, so let's just see again how we finish this up. What do you guys think is gonna happen? I'm gonna give you a hint. It's not a cock block. I have a ruling, not a reeling, a ruling. Oh, Vince, I don't think it will ever get that big. Don't worry. But don't worry, I always stick with my roots.
If we're going to enforce TOMA, you do what TOMA says is the relief, and that is that the action, they cannot continue on without it. And by the way, I'm not so sure that balancing of the interest is a criteria to be used in a TRO, but if it is, I invite you to look at the Finland case that I gave you, where that was a TOMA case involving a temporary order but in the federal court, and they did balance the interest and determined that on balance, the public is entitled to that notice, and that is worth, and it wasn't that difficult for the city to have complied. If there's any other areas or questions Your Honor wants me to address, with all of those slides flying by, I'll do my best.
I'm going to give Mr. Richards one last opportunity to address anything else, so we can wrap up.
It is the plaintiff's burden here, Your Honor, and I heard that the city had failed to present any authority for the proposition that backup documentation supplements the notice. There's also no authority from the plaintiff saying that backup documentation does not supplement the notice. Furthermore, the cases that we have cited regarding the authority of courts to enjoin elections talk specifically about alleged state statutory violation. The court was clear that that did not justify or allow an injunction of an election. And if there was a case in which a TOMA violation somehow trumped the N. Ray Morris holding, I have no doubt we'd see it, and I have looked thoroughly through TOMA cases, and there is not one, or not one that I can find. So I believe the Texas Supreme Court's ruling on prohibition of enjoining elections applies to all statutory violations. Thank you very much, Your Honor.
Thank you. Anything else?
No, Your Honor.
All right. We're going to take just a less than 5-minute break, and I will come back with the ruling.
Thank you, Your Honor.
Thank you for your presentations.
It was indeed more than 5 minutes. Can you believe that? But I stuck with it I fought the ADHD urge to move on, and I got it for us. But just for realities here. Yeah, I mean, it was probably like 8 minutes. It wasn't terrible.
All right, thank you for your patience, everyone. You
We
can
weren't
see and
very
hear
patient.
me?
Yes,
Yes,
but
Your
we
Honor.
were not patient.
All right. What I am looking at, I am looking at the notice that was provided for the 14th to determine the adequacy of the notice. That's one of the first things I'm looking at. The purpose of the Open Meetings Act is openness and transparency. And the conduct that is described frustrates this purpose and makes it so that plaintiffs would suffer irreparable harm. For that reason, the ruling of the court is the following. The court finds that defendants did not provide adequate notice of counsel's August 14th, 2024 meeting, agenda item number 12, to approve the election order identified as ordinance number 2024-0814-012. The court further finds that plaintiffs will likely suffer irreparable injury because, with the imminent deadlines to prepare ballots for a November 5th, 2024 election, the ballots may be prepared and mailed before plaintiffs' claims can be adjudicated in the district court. The court is also going to find that if a temporary restraining order is not issued, an election would be held on November the 5th, 2024, on the city's charter amendments without defendants having strictly complied with the Texas Open Meetings Act, Texas Government Code Section 551007B and 551041 to allow for public testimony on such agenda items of special interest to the public and to provide sufficient notice of the subjects of any meetings pertaining thereto. Therefore, the defendants are enjoined from taking further action on or giving effects to parts 2 through and including part 15 of its ordinance number 2024-0814-012, ordering a general municipal election, a copy of which is identified as in plaintiff's exhibit attached as P1 in plaintiff's original petition for mandamus and injunctive relief application for temporary restraining order filed in this cause on August the 19th, 2024. Now, the temporary restraining order would expire on September the 5th. Next week is settlement week. Apologies. It's not next week that settlement week is, the week after. I am able to provide you a full evidentiary hearing on your TI hearing on the 29th. Or you may wish to agree to extend until the 12th, September the 12th. We can provide, it's going to be on the central civil docket, a 3-hour setting for your TI on September the 12th. So we're talking about short periods of time, but for the 12th, it would require your agreement because it's going to extend a little bit more than the expiration that I would typically give. So which one is it going to be?
I would have to confer with my client before agreeing to extend a TRO, Your Honor.
All right. Well, in that case, what I will do is set you for the 29th because I have some time constraints with settlement week. I can't set you on the 5th. I will set you on the 29th. And if you all can confer later, you can agree. You can send this court an extension until the 12th, and we can move you to the 12th. But I'll need to know as soon as possible. The dockets are busy and full. That's going to be.
May I, Your Honor?
Yes.
On the 29th, do you have a time, and will it be heard by you?
No, it's on the general civil docket. I'm the emergency court this week. I'm the duty court handling emergencies, which is why you got me. So I would set this. It's going to be civil. I don't know who you're going to get, but you will find out shortly.
Is it 9 or 10? 9 or 2?
We would be setting this for 9. Again, if you confer and you want to agree to extend until the 12th, I know for sure we can fit you in on the 12th for 3 hours. Again, this is central civil docket. We have a central docket. I don't know which judge you're going to get. I just know the dates that I can provide to you, given sort of the wrinkle that we have settlement week coming up. So you all confer on that. Thank you for your time and your presentation. The court will sign the order and get it entered today.
Okay, and Your Honor, may I ask Mr. Richards on the record? On the record, we're not making if he will waive the formal writ service for the TRO.
Sure, you can serve me with the order is fine.
Okay, the court will be sending it to us. Okay.
All right, well, I'm going to sign it in just a moment. Thank you all for your time, and you're dismissed from the virtual courtroom at this time. Have a good afternoon.
Thank you, Your Honor.
Wow. Wow, wow, wow. What did we think? He was miffed. He was pissed off. So was Karina. She was like, that fucking PowerPoint works every time. Well, it probably works every time because you're the goddamn city, okay? And that just doesn't work all the time when you don't follow the rules, she said. Anyways, I think that it is interesting. I now, like, at the end, I realized why there were so many people watching. I'm sure local news agencies, local, like, political watchers would have been awaiting this hearing. Not to mention the, like, Save Our Springs people. So I find it interesting and thought it was good. I'm glad that you guys were here with me today. That was so fun. Please leave a like on the video. You know how YouTube Daddy likes that. He is so finicky about what he likes and what he doesn't like. Oh! That's where it hurt. Last thing is I'm going to have to post that link. Hold on. Let me get the link for the video that is not allowed, or that they want me to take down. Give me 1 second, I'll find it, and then if you guys want, you can go watch it before it comes down, just in case. And I'm sure most of us have seen it, but alas, now you will be able to link it. There you go. It's been linked in the chat. Anyways, thank you so much. MB, thanks for being here. I just thought, obviously, I thought it was a TPO to begin with. I'll just be honest. Emergency TPO. I was like, yes, look at us finding good court, Paisley. And then, you know, we listened. But I enjoyed all of it. And I especially enjoyed hanging out with you guys. Listen, I want you to remember that I love you. I'm proud of you. And I will see you in the next video. Bye. I said bye.
Ways down and ready to